Hi everyone, welcome to today's interactive webinar on merging and selling your law firm. My name's Rohan Harris and I'm a principal at Russell Kennedy Lawyers, have been since 2004, and over that time I've worked with many clients, law firm clients, in relation to their law practices, as well as a number of other professional services firms. And as for those of you who have read my guide, the guide on how to sell or merge your legal practice, 10 common steps to avoid. What I'm trying to do today in this webinar and also in the booklet and the emails that many of you would have received is share some information, some insights that I've gained over my time as a partner at Russell Kennedy, but also as a professional services lawyer to other law firms, to perhaps help you through issues that you might be thinking about in terms of your own practices. So hopefully now you've had a chance to read the booklet and digest some of it, even maybe started work on some of it, and also digested some of the emails that I've been sending around as follow-ups to get you on the journey of thinking about these issues and how it impacts on your practice. As promised, I wanted to offer this webinar as a means of giving some more insight and some more information for those of you who have an interest in the area. For those of you who are watching this webinar live, there's a hashtag link at the bottom of the screen which you can use to type your questions in. And I will be available and ready to answer those questions as we go. If you're not watching this webinar live, then unfortunately I can't offer that to you, but of course you can always contact me. I'm available on the phone. You can send me an email, you can send me a LinkedIn message, whatever's convenient for you. But I'd be more than happy to have a chat to you to see how I might be able to help you out, to share some more information with you. And I know that many of you have made contact with me already at the start of your process. So I'd like to move on now and move through some of the content. As lawyers, we're trained to drill into the detail of the issues that our clients are confronting. And sometimes we fail to ask the question as to, well, why? Why is this an issue? Why do I need to know this? Why is this a problem for me? So it's very important when you're looking at your own situation as a business owner of your own firm to ask the same question of yourself. Why is this an issue for me? Why do I need to make a particular decision? The risk that we run as lawyers trained to delve into the detail is look at the how, the what, the where, the when, all the detail and the process of going through a sale or merger. But in doing that, we can easily lose focus and not really consider the reason why a sale or merger might be a necessary thing for us to look at. So the first part of my guide, and again, what I'd really like to remind you about today is the real need to answer the why question. Because unless you do that, you really don't have the necessary, you're not going to have the direction you need to guide you through a process. And you might find yourself working through a process that's actually going to get you to a situation that you actually don't want. And you can waste a lot of time and money and effort doing that. So I'd encourage you to ask the why question in the context of your practice. And the guide includes some information in there to help you through that question. There's going to be a number of considerations or different motivations that people will have when they're asking the why question. Some people are going to be at the stage where they're wanting to retire. I'm just going to move on to the next slide. Sit yourself down with a cup of coffee and take some thinking space to do it. It's a very challenging thing to do when you're running a business practice, to actually take time out. But I think you've got to look at yourself as a business owner and take the time to ask the question. In my experience, some practitioners and firms are really motivated by the prospect of selling out and collecting a large cheque. A bit of a reality check here. I think that's often an unlikely scenario for most firms who are operating in traditional models or who might be sole practitioner firms with very small numbers of staff. Most potential buyers will place little, if any, value on the value of what you might call your goodwill or your brand or whatever offering you have to the market. So the prospect of someone paying you a large percentage of your revenue, for example, or your turnover or profit, is also very remote, unless you can show a potential buyer or merger partner that what you've got goes beyond what's locked up in your head or what you've been able to achieve in the past. You really need to have outstanding systems and processes and staff and things that will drive and continue to drive customers to your business, even if you're not involved in the business, or if you're wanting to achieve or realise some value in what you've built up. Other practitioners and firms will be motivated by the prospect of being able to achieve retirement or step back and relieve themselves of the responsibility and sometimes the headaches that go with running a professional firm like a law firm. You might also be motivated by giving someone else in your firm or someone else that you know an opportunity to take over ownership of your practice and therefore ensure that your staff and your clients continue to be looked after after you've stopped involvement or ownership of the business. So many of the firms that I've worked with in the past have figured this out, and they come to me with a very clearly defined answer to the question of why do I want to sell or merge. And of course that makes our job a lot more straightforward, because we can then move into the implementation phase and actually work on getting the job done for them. Equally though, we have experience with others in the industry who actually need help to get through this question. And again, this is where we I believe can offer assistance in helping you through that process, and being someone who can come in and look at this from an external perspective and help you through the process. So whilst I'm a lawyer first and foremost, I'm not a broker. I'm not a matchmaker, if you like, in a professional sense. But over the course of the work that I have done, we have built up a number of very good contacts and knowledge about what's going on in the industry and what's available out there. So there may be instances where we actually do have clients who may be on the acquisition path based on work we've done with them before, who may be interested in your practice. We also have built up very good relationships with professional bodies such as the Law Institute of Victoria, and also organisations like the Legal Practitioners Liability Committee, who obviously have an interest in this area in terms of succession and risk, and the prospects of law practices. So we take approaches and queries from them. We also can bounce things off them. So it's a very good network, I think, that we've built up that I'd be happy to introduce you to if you feel the need. There are also a number of other recruiters and practice brokers who are operating in the legal space. Some of them aren't obviously evident if you do a Google search or do the usual types of searches, but we can certainly put you in touch with people who know the industry and who may be able to put you in contact with other potential parties to talk to. The other thing that I should also mention is that Russell Kennedy, as a progressive and growing firm, are also looking at opportunities to merge with suitable practices where we believe that there is a natural fit or some sort of benefit to us for doing that, and we've actually been able to achieve that with a couple of acquisitions in recent years as well. So that's always a possibility too, and something I'd be happy to discuss with you if if I think there's some sort of synergies that we could look at. So just to cover off on this slide, I'd encourage you to ask the why question before the how and before delving into the detail. And if you need help with that, then give me a call and I'm sure we can have a chat about what the why question might look like for you. Moving on, so assuming you've answered the why question, what's the next step? This is where we start to get into the very start of the implementation of whatever you might plan to do. So what you need to be able to do, obviously, is come up with a selling proposition for your firm. You need to ask yourself the question, well, what do I have to offer? Obviously, it's got to be more than just a cup of coffee, but again, you really need to give some thought to this so that when you do start talking to people out there in the market who might be interested, then you have a very clear value proposition or selling proposition for them. So there's a number of things that stick out to me when I think back to some of the transactions that I've worked on in the past, things that have made those deals successful. Like anything, like any business, any successful business is going to rely on a quality stable of clients who come back time and time again, and who have the capacity and willingness to pay for the services that you're offering them. So law firms are no different from that to the general business community in that regard. So for a larger or mid-tier firm in particular, they're going to be looking at quality relationships with clients like trading businesses, property investors who are coming back time and time again to do transactions, government who have a large body of work or maybe have panel arrangements which lock in a certain volume of work year on year, typically speaking, or larger institutional clients, obviously again with the same things in mind in terms of volume of work and ongoing fee opportunities. That's not, of course, the case for all firms. For smaller firms or more boutique firms, having a large volume of clients who maybe only deal in specific transactions, one-off transactions, but where the attraction of those clients is supported by very good branding, very good marketing systems, and good staff, can also be attractive to law firms, and particularly at the moment with the legal market, which is we're seeing instances where firms that typically would have only operated at the higher end of the market are also getting into the more volume-based transactions and services, and so unbundling their services and offering a range of different offerings, a range of different services through different platforms, different pricing structures. So again, firms with very systematised, high volume client offerings can be attractive to a range of firms in the market, not just at the smaller end of the scale. I know, speaking it from Russell Kennedy's perspective, but also from the perspective of the clients I've worked with, we obviously look at profitability. Profitability is key to the success of any business, and again, law firms are no different. And so we look at profitability, but after normalisation factors, and in particular after normalisation for partner salaries. So the real profit that sits behind the firm. If there's a profitability case around a firm and the firm can be easily integrated into another firm, then of course the business case for merger or some sort of sale transaction is much higher. Strategic location is also important for many firms, particularly those firms that part of their model is to attract, again, sort of one-off clients, people who are maybe in the market for a lawyer in a high street scenario where they have a particular issue and they're looking for someone to assist them with. They may have no previous relationship with any particular law firm. So it's very much a shop front or physical presence that's very important for that type of client. So a strategic location that's maybe one firm has and that another firm's looking for can be a really good value proposition for the buyer or the merger partner. Complementary skills and market presence are also highly valuable to some firms who are looking to fill some gaps in the services that they presently can't offer or feel that they need to offer in order to keep their existing clients happy. I've also seen instances where firms that have previously relied on so-called off-panel arrangements where they continue to receive the opportunity to get work from clients such as government clients or corporate clients who have moved to panel arrangements. I've seen those opportunities diminish. So a firm in the position that's relying on an off-panel arrangement to receive a large body of work will be placed in a position often where they will need to look at merger or sale if that off-panel arrangement is closed off. Of course, if you're the merger partner and you can offer a continuity of opportunity to service that particular client because you're on a panel, then that will be a significant factor often in deciding whether to go ahead with a merger or discuss a merger. I've mentioned filling gaps in key service offerings. Another thing that can be attractive, which again is perhaps a different model to the typical sale or merger scenarios, is where younger members of a firm might be attracted by the prospect of taking an equity interest. So in this sense, the merger or sale might actually take the form of a management buyout effectively, where the younger members of the firm come up with an arrangement with the partner who's looking to exit to acquire their equity, and that may occur over a period of time. And we've worked on those types of equity restructure, equity succession transactions as well. So hopefully that's helped you consider what you have to offer. It's a very important thing that you need to clearly define so that you're in the best position to put your best case forward if you have the opportunity to talk to a merger partner. So the next question you need to ask yourself once you've come up with your value proposition and what you have to offer is to work out, well, who am I going to sell my firm to? Who am I going to merge with? And again, the answer to this question isn't always obvious. And this requires more stepping back and thinking about what do I have to offer, who might be interested in what I have to offer. And so the typical people you might think might be interested aren't always that's not necessarily the end of the story. So the first thing I'd encourage you to do is to look at those firms who you perceive or who may be perceived as being your competitors. Perhaps they're the firm that you've spent your lifetime of work trying to compete with, trying to capture work off. Perhaps they've taken some of your clients. They might be perceived to be doing well when your firm's not doing as well. I'd encourage you to think about the types of firms that might fall into that category for your practice. It could be based on a complementary service offering. So if you're actually competing for the same group of clients based on a similar service offering, that actually might be part of the answer for you. The other obvious competitive market factors might be in terms of their client types or their geographic location. It goes back to the old saying, if you can't beat them, join them. And I'd encourage you to think about that sort of option, as hard as it may seem, based on a competitive relationship you may have had over the journey. But I really think it's no different to what other businesses go through, and many of the other merger transactions that I work on outside of the professional services businesses and legal firms have involved that very thing, where it's a competitor takeover. I think this actually does go on a fair bit in the legal industry, but perhaps you don't hear about it, or perhaps it's not marketed in the sense of being a merger or acquisition. Often it's actually brought about by means of the recruitment of key individuals together with key assets that come with the firm and the individual. For example, with smaller practices, what often happens is that the staff and the ongoing files are transferred to the merger partner, and it's really affected by means of an asset transfer. And also what often happens is the partners of the selling firm, if you like, they may be offered partnership in the merger partner, so it's a direct swap. Assuming there is sufficient relativity between the two firms, or the profitability that the outgoing partner or the transferring partner can bring to the table for the new merger partner. Other times, if the outgoing partner is not looking for ongoing partnership, but the outgoing partner's relationships with the clients that are hopefully transferring, that sort of scenario is often dealt with a consultancy, for example. So the outgoing partner would agree to take on a consultancy role with the acquiring firm, and part of their role would be to ensure that the client relationships continued for the benefit of the acquiring firm. And typically there'd be financial KPIs and so on attached to their remuneration package under their consultancy to ensure that happened. The other thing that law firms, being law firms, will absolutely be have an awareness of is the risk that goes with a merger in the true sense. And what I mean by merger in the true sense is a situation where you effectively have two firms or two partnerships come together where the liabilities, known or unknown, are effectively assumed by the acquiring firm or the merged firm. And of course that presents some risk for the acquiring firm. And again, that's another reason why the asset transfer method that I just mentioned is probably the preferred method, particularly if you've got a larger firm that's acquiring a smaller firm. In cases where you have two large firms merging together, that may be a little more difficult, and part of the work that we would do there is looking at ways in which perhaps the two businesses can be restructured in order to minimise that risk. But again, it's very the situation varies greatly between different scenarios. The other potential field of candidates for merger or sale that I'd encourage you to think about is the accounting firms and professional services. So we've seen the top end accounting and professional services firms get back into legal in a big way in recent years. But I also think the same may transpire with smaller accounting firms, often based out in the suburbs, who feel that there's some benefit in capturing client relationships and perhaps new revenue streams by actually partnering up in some way with local law firms. So I know one firm in particular in the suburbs in Melbourne that's done this, and I think it'll be interesting to see how that transpires over the coming years as more and more smaller law firms and sole practitioners, for example, are faced with these challenges. And so it's the option of looking at accounting firms as potential merger partners should definitely be on the table. Otherwise, if you're a bit stuck on answering the question of who should I merge with, who should I speak to, then again, I'd encourage you to come back to us and speak to us. If we don't know someone who's interested directly, then we have a network of brokers, recruiters, consultants, and people in the legal industry associations and organisations who may have an answer for you and may be able to help you through the process. So to sum up, if you're not sure about who you're going to sell or merge with, then I'd encourage you to ask us as well and others with knowledge. And we can put you in touch with people who may be able to identify appropriate firms to talk to, brokers, recruiters, consultants, and of course your industry association. So now I'd like to move on to the question of how and when will I do it? How and when will I sell or merge my firm? That's really going to depend on how much time you've got. Those firms who give thought to these sorts of issues early on in the process, or at least some years out from when they know that they're going to be confronted with a decision about merger or sale, have the luxury of time, and in my experience, they're the ones who are typically best placed to achieve the best outcome. Again, that might not be in the form of a large cheque, in my experience, but in terms of whatever merger deal or restructure or whatever it looks like they can strike, that's the scenario that's going to achieve the best outcome. If, however, you don't have that luxury, and this is particularly true of many smaller or sole practitioner firms, where the partner is in a position where he or she really needs to look at retirement, or in situations where, due to some personal circumstance, they're no longer actually able to continue in the practice. They, of course, don't have the luxury of time, and it becomes very difficult for firms and practitioners in that position to actually achieve the outcome they may have expected, and that can be a really challenging situation for people in that position to go through, and I've seen it firsthand. So for those sort of people, if there's an option for a continuing consultancy role, or a role which otherwise is targeted at bringing client relationships across to the acquiring firm, then there is still a prospect of achieving and striking a deal that still has some sort of upside for the smaller practitioner or the smaller firm. And typically those sorts of arrangements, the consultancy arrangements that I spoke briefly about before, will have some sort of upside, but also some sort of risk built into them to address the potential for clients actually not coming across, which of course would be a bad outcome for the transferring or the selling practitioner. So their remuneration arrangements will often be structured such that they have a financial incentive to bring client relationships across. And that's also going to be necessary for the larger firm that's looking to get the most out of the merger in order to cover the risk of clients not coming across. So the question of how and when am I going to merge or sell is really going to be dictated by the why question, and how much time you actually have before you have to make the call and actually complete the transaction. The next couple of slides, I'm really going to refer back to my booklet, which has a bit of a checklist, if you like, as to things you need to do once you've answered the initial questions. So I think it's very important when you're going to the market with your firm to present yourself in an attractive way, and that involves getting your practice sale ready or merger ready. So being prepared, and it's no different from being faced with a situation where a client might come and see you, and you know that it's a difficult job in front of you when the client themselves is unprepared, and part of the work you have to do is actually getting them ready so that they can actually give you the information you need to help them. So the same is no different from other firms that you might want to talk to in relation to a sale or merger. You've got to get yourself prepared. You effectively need to do a due diligence on your own practice and put yourselves in the shoes of the buyer or the merger partner. And what impression do you think they would gain if they saw your firm in the state it was now versus in the state that it could be if you actually take the time to prepare the practice for sale or for merger? And that requires some time and effort and investment to get you to that stage. So I'd refer you to step 5 in the guide for that checklist, which has got all the information you need, I think, to get yourself on the prepare pathway to selling your practice. Along the same lines, step 6 in the guide deals with the process of preparing an information package about your practice. And again, it's like selling your house. If you present your house in a very professional way, then you're much more likely to get people who are attracted to it and much more likely to have them pay you or at least give you the deal that you were perhaps hoping for. So the same's no different when you're preparing and presenting your practice. I think it goes a long way to improving your offer and improving your prospects if you can present it in a professional way with a proper pack of information that would deal with all of the key things that a buyer or merger partner is going to be looking for. So particularly financial information, information about your clients, your history, the staff and their performance, and a whole range of other factors, and really focusing on what you perceive to be the selling points of your practice and what may be attractive to your merger partner. What have you got that you think they might be looking for? What can you offer them that's attractive to them? And they're the sort of things that I'd encourage you to do when you're preparing the information package. Again, if you're not comfortable doing that yourself, then there are other professionals and consultants, including ourselves, out there who can actually help you through that process. Naturally, as lawyers, we also think in terms of confidentiality, and the same is no different when you're selling your own practice. The risk that you run of having information leaked about your practice, the fact that it might be on the market, before you're actually ready to communicate that to your key stakeholders, particularly your staff and your clients, there's a large risk there if you get that wrong. So confidentiality in terms of the whole process is very important. And again, in step 7 of the guide, there's a number of tips in there that I think you should use and implement if you're going through this type of process yourself. And part of that looks at the engagement of consultants and third parties such as us or your lawyer to actually help you through that process and maintain that confidentiality around your practice. And you would think this point is obvious, but step 8 in the guide, something that I think can be overlooked, is to document the deal in writing. You've got to step yourself outside of your law practice hat in this scenario, and again, put yourselves in the shoes of a client. And if you were acting for a client in this situation where they were selling their business, would you advise them to put their to document the deal in writing? Well, yes, of course you would. So the same is no different for your practice. And what the document looks like will, of course, depend on how you've structured the transaction. So it can take different forms, but at the end of the day, you need to have this sort of this agreement. It's an important agreement. It's got to be committed to writing in the usual way and signed off, so that you've got comfort and certainty about the deal proceeding, or rights and remedies if it doesn't proceed. The other topic that I covered in the guide in step 9 is about planning for your future. And if you've done a great deal, then you may have a nice little piggy bank that you can sit on the beach with, and enjoy the spoils of your transaction. But that may not always be the case. But what I'm really trying to get at here with this slide is to send a message that you need to think about your own personal situation and affairs when you're dealing with a major sort of transaction like a sale or a merger of your practice. And just like you would advise your clients to do, you should be looking at your wills, powers of attorney, and other personal affairs to make sure that the investment that you may have realised in the sale of your practice or merger is protected and preserved for the future. And so I'd encourage you to think about your own personal situation and not just about the business. It's easy for us to sometimes lose focus on that. Finally, if you've been fortunate to get to the stage of doing a deal, then there are some important completion steps that need to be followed to make sure that the deal is completed smoothly. And again, like most business transactions, there will be a range of third parties and other stakeholders that you'll need to consult as part of the process. And part of our engagement, if you would engage us to act for you in your transaction, would be to help you through this process. So the typical parties that you'd need to be speaking to, apart from your own clients and staff, of course, and they'd be essential, very important, obviously, would be parties like your landlord, your banker, your accountant, your tax advisor. And of course, if you're under some sort of consulting deal with your new firm, then you'll need to be very focused, obviously, on preserving client relationships, making sure the clients come across, and hitting those KPIs so that you can maximise whatever deal you've struck. And what we do as part of this process is help you come up with a checklist that then we'd work through to make sure the sale and the merger was effected in an orderly manner, and that the deal's done and everyone's happy. So to sum up, the best way and the most effective way of working through all these completion items is to prepare a checklist, work out who's going to do what, and then work through the checklist very systematically in order to ensure that all the boxes are ticked and you can move on. So this brings me to the close of the webinar. I'd like to thank you all for your time and attention, and I really hope you've gained some benefit and some insight into listening today and watching today, but also from the material that I've put out. I'd encourage any of you who are thinking about going down a sale or merger process to give me a call, and I'm sure there's something that I've gained over 18 years of practice and several years working in the field of professional services, and particularly with many law firms and lawyers, that may be a benefit to you. So please don't hesitate to give me a call, or you can send me an email, or you can link in with me, whatever's convenient with you. And I look forward to helping you and hopefully on a successful journey around the sale or merger of your practice. Thank you.